The Supreme Court today ruling on two cases impacting immigration. In one ruling, the court saying the Trump administration can turn away asylum seekers at the U.S.-Mexico border. In another, the court says the administration can cancel the temporary protected status of Haitian and Syrian asylum seekers.
America, the Supreme Court handed Trump two huge wins today, both on immigration, both 6-3, both decided the exact same way. They opened the dictionary. Two regular words you learn in third grade: arrive in and the word temporary. Both of these words were already sitting in laws Congress wrote. The lower courts have been pretending those words meant something completely different for years. Today, the Supreme Court said no, and they actually mean it. The other side says America lost today. Real people are scared tonight and today, and that part is absolutely real. So who's right? And what do those two words actually mean for the border right now?
He talks about saying that in ordinary speech, no one would say that a person arrives in a place, like a home, a city, or a country, before the person enters that place. So that is the basic logic here from the conservative justices.
What is up, guys? Tyson DeLaCruz here. Thank you so much for rocking with me. Let me start with win numero uno, win number one, the case called Mullen v. Ala Ortolaro. It's a big name, a small question here. And here's a question that the court had to answer. If somebody walks to the U.S.-Mexico border, but is still standing in Mexico, do they, quote unquote, arrive in the United States? The lower court says yes. Standing at the gate counts as, quote unquote, arriving. Justice Alito said no. Go ahead and pop up his exact words on the screen so we can read it. In ordinary speech, no one would say that the person, quote unquote, arrives in a place, for example, a house, a city, or a country, before the person enters the place. Hopefully you guys followed along with me there, and hopefully you read that nice and slow. You have not arrived at my house until you walk through the door. Standing at the porch or standing at my driveway does not count of you entering my home, arriving in my home. I hear you. You're not in. This is a sentence that a third grader absolutely understands. The lower courts argue about it for over a decade. You're probably asking yourself, Tyson, why does this matter? Because the current law says this. Current law in the United States, anybody who, quote unquote, arrives in the United States has the right to apply for asylum. The lower courts said that right kicks in while people are still standing in Mexico, while they're still on the outside. Alito said the law means what it actually says. You have to actually enter first. The difference here sounds small, but it's not small at all. The policy this unlocks is called metering. Let me explain that really quick. Metering means when you control the line instead of processing every single person who walks up to the border. You set a number per day. Everybody else waits in Mexico. Metering started under the Obama administration in 2016. Trump used it. Biden ended it. Courts blocked Trump from actually bringing it back. Today, the Supreme Court said the legal foundation for metering is absolutely correct. You have not entered yet. They have not, quote unquote, arrived. The right to asylum has not actually kicked in yet.
High Court's actions clear the way for the Trump administration to turn back migrants seeking asylum at the border. The policy is currently not in place, but it limited the number of people who could apply for asylum each day during President Donald Trump's first term, though Democratic presidents have used it as well.
Advocates make a real point. Makeshift camps, people waiting at the border, a lot of stuff going on. But here's what the court said back. The word, quote unquote, arrived is a line that Congress drew. Until you cross that line, you are not in the United States. You are in Mexico. Congress put that word into law on purpose, and it actually means something. The lower courts have been trying to erase that line for 10 years. Today, it went back. Win number 2, this is about something called temporary protection status. That's TPS for short here. Simple idea. Let me walk you through it for those of you that aren't familiar with it. In 1990, Congress created TPS, so Temporary Protective Service. And here's what the deal actually wrote. If your home has a major disaster, we're talking about an earthquake, a flood, a war, the United States can say, hey, you can come here and stay here for now. You are safe here for now, but it ends as soon as the emergency is over. The T in TPS means temporary. It always meant temporary. It didn't mean something else. Congress also wrote this in the law, and I'm putting the words on the screen so you can actually see it. The TPS status plainly bars consideration of recipients' non-constitutional claims. It also allows no judicial review of any determination with the respect of the termination of the TPS designation. Plain words here, plain English, no legal jargon here. Congress said the Secretary of Homeland Security decides when TPS ends. Courts don't have the right to vote for it. That is what the phrase no judicial review actually means. The courts get to sit this one out. That sentence, you guys, has been in law since 1990. Over 350,000 people from Haiti had TPS. Around 6,000 from Syria. Some have been here for many, many years. The Trump administration says conditions have changed enough to end the TPS designation. The lower courts blocked it. The Supreme Court said, read the 1990 law. Congress gave this to the executive branch. Courts, step aside. And the radical discrimination claim, the dissenting justice said Trump's past comments about Haitians proved real radical motivation. Alito looked at the full record here. His answer, if the policy applies to nearly all TPS countries equally, you cannot prove race was a specific reason to one country's termination over the general opposition of the entire program. Watch Bill, a legal analyst on Live Now Fox, explain this moment the ruling actually dropped. Listen to how simple he makes it.
This is an executive branch decision. I mean, originally it was Congress gave the decision to the Attorney General. Once Homeland Security was created, those duties fell to the Secretary of Homeland Security. And remember, Congress in its own statute said no judicial review. So obviously, it was expected that the executive branch would be making these decisions under the limited guidelines Congress set.
The courts wrote it. Executives enforce it. Courts stay out, written in 1990. Clear and plain. And the lower courts spent years jumping on it anyways, blocking it, extending it, freezing it. I'm not mad about it anymore. I don't have the energy to be mad about this crap. It's just a piece of paper from 1990 that says exactly how it works and should have been working the entire time without any opposition. Both wins today work the exact same way, not the same legal argument, not the same law, the actual same method. Read the words they said, believe the words they said, and they actually said, mean it. And that's it. Plain and simple here. Justice Alito wrote both opinions. Same man, the same morning. He didn't invent any new tools. He didn't hand Trump new power. He picked up a law that was already written and said, this is exactly what it says. It says it right here. Read it. The lower courts lost not because they were out-argued in this situation. They were just simply outread. Now, I want to show you the real human part of this story because there's people here, real ones, real people who built lives here who are now scared because their temporary protective services ran out. Again, keyword temporary. And you need to see it because I want to play both sides here.
News of the Supreme Court's decision rippled through members of South Florida's Haitian community gathered at Miami City Hall to protest the city's agreement with Immigration and Customs Enforcement.
All of these battles are intertwined.
My people, they can't go back. It's real. The reality in Haiti is real.
And that woman is not wrong here. The State Department still has a level 4 do not travel warning in Haiti. That is one of the highest levels ever issued, same level as an active war zone. But I want to be completely honest about something. This ruling is not whether about Haiti is safe or not. It is about one specific question. Who is in charge of deciding when TPS actually ends? The court says we are. Congress said in 1990 the Secretary of Homeland Security is. The Supreme Court said Congress answered this question in 1990. Courts step aside. Now let me show you the strongest argument from the other side, because the opposition is not making things up here, and you should hear what they have to say so we can completely understand the entire picture here.
Right now, America lost. There are going to be a lot of jobs that are open and a lot of people in home health care industries that are not going to receive any service because their providers are going to be removed from the United States.
Alan Orr, sharp lawyer, real argument here. Home health services, farming, construction, these are the type of industries that run on TPS workers right now. And that is absolutely true. And it deserves to be said. If TPS workers are this important to these particular industries, why has Congress not passed a law to protect them in the past 35 years? It's not a trick question here. It's the only question that actually matters. The Supreme Court cannot write laws. They read laws. They cannot fix what Congress refused to do. That is the design of the whole system. Alan Orr is arguing at the wrong address. The argument belongs on the floor of the U.S. Senate, not at the Supreme Court brief. And here's what tells you the other side already knows that the text argument is lost. Justice Sotomayor did something in the courtroom today that almost never happens. Watch.
When Justice Sonia Sotomayor, who's the court's senior most liberal justice, got up to deliver her dissent, normally in many of the cases, the justices don't actually announce their dissent aloud in the courtroom. But the Hill's Sarah Davis, who was in the courtroom for us this morning, watched as Sotomayor actually read that dissent aloud from the bench. And this is when the justices reserve it for cases when they really want to express their strong disagreements. So the fact that Sotomayor decided to read that dissent from the bench just gives you an idea of how big she saw this case. So she actually said at one point in her dissent that people are going to die actually because of this decision. So
reading the dissent out loud from the bench in the room. Justices maybe do that apparently anywhere from 3 to 4 times in a decade. It means that they think that the decision is completely wrong. And I need you to hear my voice. So I'm going to read this out loud, so you're not just reading the document. And she said that people are going to die. But here's the part that she could not point to. Okay, one word in the law that says courts can review TPS decisions. She pointed to the consequences. She pointed to what should be true. She pointed to what is right. Alito pointed to actually what is written. No judicial review. 4 words here in law since 1990. In a court, the written words are the job. Consequences is what should be true. That is the job of the people that the voters elect. Her anger is probably real. Her argument belongs in the Capitol, not in the courtroom. My friends, the legal level was already there, written down in 1990. Nobody created anything new. Alito found the lever. He just pulled it. The lower courts never had the authority they spent years claiming that they had. America, 2 things before I go, and neither made the video before this recap. 1, the minute that the ruling dropped, the top lawyer of the Department of Homeland Security put out a statement. He is the DHS's general counsel. And here's what he wrote. Pop it up on screen. We had to go all the way to the Supreme Court of the United States to vindicate the principle that an alien is not in the United States until he actually is, in fact, in the United States. They had to take this to the Supreme Court of the United States to prove that in means inside. That is how long the lower courts kept this game just going. This is how far this had to travel from a plain meaning to 2 ordinary words here. 2, both winning opinions today were written by the same person, Justice Alito, the same man, the same morning, 2 same cases, 2 words, 0 new laws. That's not luck. That is a method. The lower courts, they're now on notice. Read the law, believe the words, and the method works. Believe me, it'll be used again. The Birthright citizenship case drops next week. That one, trust me, you guys, is going to be bigger than both of today's situations combined. Don't forget to hit that like and subscribe button so you don't miss out, and make sure that you hit that notification bell as well. Let me know what you guys think about this. Drop it down in the comment section down below. Smash the like button if you kindly would. Share, subscribe, and as always, guys, I'll catch you on the next one.